And now I'm showing volume now, which is phenomenal. And look, I'll even turn it up. Look at that, boomer tech. All sorts of boomer tech. All sorts of boomer tech. So to start this all over again, about a month ago in Springer versus the 7th Judicial District Court, were you guys outside of the gate? Was that what was going on? In Springer versus the 7th Judicial District Court, the court itself issued sua sponte a order to show cause, demanding that the plaintiff, James Springer, show cause as to why the court should not dismiss the case. And then it allowed the defendants to respond to that. And if you remember, I said at the time that the court issued the order to show cause that Springer lost. At that time, Springer lost. And then when I read Springer's response to the court's order to show cause, I said, well, Springer's definitely lost. The defendant's reply did not impress me at all. They didn't respond. They didn't address any of the issues that Springer raised, and their arguments themselves were incredibly weak. We're going to go through this, hopefully fairly quickly. This is where James Springer, i.e. James Freeman, the man who picked the best attorney in New Mexico to handle his case, the best. This is the best New Mexico has to offer. And if you think I shit on attorneys all the time, well, this is why. This is why. Why is a first-year family law attorney calling it so far in advance? And everything the court points out here are things that I have pointed out. You could have just watched my video and predicted exactly what the court was going to say. So the matter came before the court. Background, we're not really going to go over that too much because I don't really care about the background. We've all been through it on. Is reverb on? There's only one mic. There's no sound coming out. I don't know, bro. Is there reverb coming on? Is there reverb on? Why are you all... Turn off desktop audio. So there's literally no sound coming out on my end. Not that there would be. But I don't know how you could have reverb on. Do I need to plug in earbuds? Do I need to start this over again? Can someone in chat tell me if I need to start this all over again with earbuds on? Is this a problem? Is this a problem? Anybody in chat? Sounds fine. Okay, so it's just Lauber being a boomer. All right, perfect. All right, so we're going past the facts. So count one, alleged claim under USC 1983, predicated on violations of First Amendment rights, freedom of speech, and the press. Which plaintiff characterizes as viewpoint discrimination, which was retarded. Specifically alleges that Chief Judge Murphy and Judge Murdoch Poff engaged in viewpoint discrimination by banning and excluding plaintiff from a places SIC, which means that the error was in the original, and hearings prohibiting him attending and reporting on public matters. Count two is another 1983 action predicated on retaliation in violation of the First Amendment rights to freedom of speech and press, including denial of the protected liberty interest in petitioning the government against all defendants. I don't really care what it specifically alleges because it's fucking retarded. Count three alleges another 1983 action predicated on procedural due process violations, apparently against all four defendants. You know, if people are still guessing by the time that you've done a second amended complaint, if they're still guessing, if the judge is still having to fucking guess who the defendants are for a particular cause of action, you know you done fucked up. That is not the quality work of the best attorney in the state of New Mexico. And I understand that James Freeman has an ideological bent. I understand he has a political bent that may align very well with the ideological and political bent of this A. Blair Dunn guy. Unfortunately, that doesn't mean that A. Blair Dunn is the best attorney in the state of New Mexico. You could tell how good an attorney is by the quality of his work, by the quality of his work product, by his research, by his knowledge, by his ability to, identify which defendants he is making a claim against for a specific count. Basic, like this is kindergarten lawyer stuff. This is the most basic of stuff. This is like, if you can't identify who you're making the allegation against, then there's a real fucking problem. Count 4 alleges a violation of Article 2, Section 17, 18, and 23 of the New Mexico Constitution against the 7th Judicial District Court only. Discussion. For the reasons that follow, the court finds that counts 1, 2, and 3 must be dismissed with prejudice in part and without prejudice in part, and the count 4 must be dismissed without prejudice for lack of subject matter jurisdiction. Now, I did not call that the court would grant leave to amend, but I did say that as far as the declaratory relief, that the court could grant leave to amend. I didn't know if the court would or wouldn't. So, that part was a little fuzzy. I thought maybe the court had enough of how incredibly incompetent the attorneys were in this case, to the point where the court might be like, no, I'm just going to not grant leave to amend. You'll have to refile and pay the extra $400. Yeah, it was Boomer Tech, wasn't it, Lauber? Boomer. And the count 4 must be dismissed without prejudice for lack of subject matter jurisdiction. That doesn't mean that he will be able to refile, that Springer will be able to refile count 4 in a federal district court. It means that he could file it somewhere else, in a different district court, not a federal district court. Counts 1, 2, and 3, judicial immunity, quasi-judicial immunity, declaratory relief for past liability, and individual capacity claims for prospective declaratory relief. As discussed below, the court finds to the extent that counts 1, 2, and 3 seek injunctive relief, the individual defendants are entitled to judicial and quasi-judicial immunity, and to the counts 1, 2, and 3, and to the extent counts 1, 2, and 3 seek 1, declaratory relief for past liability, and 2, prospective declaratory relief in their individual capacities, they fail to state claims upon which relief can be granted. Judicial and quasi-judicial immunity. So they're not liable for their judicial acts. And if you think I'm skipping through this quite a bit, you're right. Because I want to get to where the court actually addresses. Here the court finds that counts 1 through 4 all predicated on the issuance and execution of 1, Chief Judge Murphy's administrative order barring plaintiff from entering the Torrance County District Courthouse in Estancia, New Mexico, no superior for a hearing having specific court business, and then only with a law enforcement escort. 2, Chief Judge Murphy's amended administrative order barring plaintiff from all the 7th Judicial District's magistrate and district courthouses, unless appearing for a hearing or having specific court business, and then only with a law enforcement escort. 3, Chief Judge Murphy's decision to remove plaintiff from a hearing being held virtually via video conference, and 4, Judge Murdoch Poff's order excluding plaintiff's presence at a hearing in a civil matter. Because issuing administrative orders is a function normally performed by a chief judge, it is a judicial act to which judicial immunity applies. And to be sure, judicial control over who may appear before a judge is inherently a judicial act, not an administrative one. So that covers Murdoch Poff. As such, an order or other act barring an individual from entering the courthouse or a courtroom is a judicial act to which judicial immunity applies. Yada, 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 yada. Because the administrative order and amended administrative order are facially valid, defendants Jones and Rossengall's actions to execute and enforce those orders are subject to quasi-judicial immunity. Yada, yada. Plaintiff argues, this is where we're going to get to the best attorney in New Mexico's argument that a fucking first-year family law attorney reading it on its face figured out that it was fucking wrong. Plaintiff argues that the Supreme Court's decision in Supreme Court of Virginia versus Consumers Union of the United States permits him to maintain an action against the defendants for declaratory and injunctive relief. Plaintiff is half correct. Judicial immunity does not necessarily foreclose declaratory relief in the appropriate case. Declaratory relief in the appropriate case. However, the 1996 amendments to Section 1983 supersede Consumers Union with respect to injunctive relief. Oh my, I'm so shocked. Thus, the doctrine of judicial immunity now extends to suits against judges where the plaintiff seeks not only monetary relief, but injunctive relief as well. Accordingly, to the extent that counts 1, 2, and 3 seek injunctive relief, the courts find that they are barred by absolute judicial and quasi-judicial immunity. Fucking amazing. Unreal that would happen. Declaratory relief based on past liability. On the other hand, as mentioned above, Section 1983 does not preclude declaratory relief against a judicial officer. However, not every plaintiff is entitled to this remedy. Rather, the plaintiff must be seeking a declaration of future rights and not simply a declaration of past liability. Declaratory judgment is meant to define legal rights and obligations of the parties in anticipation of some future conduct, not simply to proclaim liability for a past act. See, I thought this would be handled under the Rooker-Feldman doctrine. I don't know if the cases the court is citing here are kind of basing their decision in this, because the problem is with declaring liability for past acts is basically the federal court would be saying that the state court effed up in that decision, which is essentially like a appellate review of the state court decision. And the federal court is not an appellate court for the state court, despite what Eline thinks it is. So, fucking Eline. Eline thinks that Chili's going to appeal to the Ninth Circuit. Fucking stupid. Fucking stupid. Unbelievably stupid. That guy, he is amazingly stupid. So the court finds that to the extent counts 1, 2, and 3 seek a declaration regarding the constitutionality of Chief Judge Murphy's decision to eject plaintiff and Judge Murdoch Poff's order excluding plaintiff and the defendant Jones's letters informing plaintiff and the past actions of defendant Rossengall, they must be dismissed because they're seeking a declaration of past liability. How your Kirby case going, CJ? That's not the real CJ Grisham. That's somebody playing CJ, Chicken Beak. Because actually CJ calls himself Chicken Hawk, which I think is worse than calling himself Chicken Beak. Because Chicken Hawk implies that he is an older gay man who likes to prey on, let's just say young gay men. Or young men, generally. Or maybe not men at all yet. Chicken Hawk is not a very good thing to call yourself. But he did it, unironically, because he got it when he was in the Army. That was the nickname he got, and I guess he was just so stupid, or maybe he thought that it was a kind of a bro name, like, oh man, a chicken hawk is a hawk, and so yeah, I'm like a bird of prey, and these guys gave me a cool name. It's kind of hawk. It's not quite an eagle, but it's kind of a hawk. You know what I'm saying? Not realizing that they were actually insulting him, because he's not smart enough to realize stuff like that. Anyway, continuing on, blah, blah, blah. So, because claims seeking a declaration of past liability are not cognizable, they are dismissed with prejudice for failure to state a claim. Declaratory relief is unavailable to adjudicate past conduct. He was grateful to be given a nickname. That's something. That's sad. Yeah, that is sad. Yeah, that's your boy Chicken Hawk. He is a sad individual. Individual capacity claims for prospective declaratory relief. Although the court finds that counts 1, 2, and 3 also seek prospective declaratory relief to the extent they seek a declaration that Chief Judge Murphy's administrative order and amended administrative order continue to violate his constitutional rights. They must be dismissed because they are asserted against Chief Judge Murphy in her individual capacity only. So essentially what the court is saying is that he's going to have to amend his complaint to allege, well, to seek declaratory relief, prospective declaratory relief against Judge Murphy only. Under 83, a plaintiff cannot sue an individual in their, or cannot sue an official in their individual capacity for injunctive or declaratory relief. Yada yada, we've been over that before. Here, the second amended complaint names Chief Judge Murphy in her individual capacity only. Accordingly, to the extent counts 1, 2, and 3 seek prospective declaratory relief, they are dismissed without prejudice for failure to state a claim. In sum, counts 1, 2, and 3 are dismissed with prejudice to the extent that they seek injunctive relief because the individual defendants are entitled to absolute judicial and quasi-judicial immunity. Yes, I am actually... You should be able to see the chat on your screen, Mr. Jackson. So you could see your own chat pop up, which means that I must really be live. Dismissed with prejudice to the extent they seek injunctive relief because the individual defendants are entitled to absolute judicial and quasi-judicial immunity from such claims. 2, dismissed with prejudice for failure to state a claim to the extent they seek a declaration of past liability. And 3, dismissed without prejudice for failure to state a claim to the extent they seek prospective declaratory relief against Judge Murphy. Mastiff Heart Springer is James Freeman. He is the rather ginger fellow who has ginger fellow, beard, blue eyes, short hair, and yeah. Anyway, he I guess he grew up in Arizona. He moved to Texas. He accumulated criminal records, like misdemeanors, in both states, in both Arizona and Texas. And then I guess he made enough money doing his YouTube content that he could buy a homestead in New Mexico, where he had enough land and room to raise his kids, which is good. You know, again, I agree with Freeman on James Springer on a lot of things. Politically, I think we're kind of on the same page on a lot of things. I think we disagree a little bit on the approach to it, but I moved out to the country too when I had enough money, and I support him doing it. And he's gonna homeschool his kids, and I hope he does. Make them independent thinking, independent minded young people that can that don't just follow the herd. All right, so, and then the 11th Amendment immunity, just so we're going to get down to it. Yeah, you can't sue the government of a state unless the state grants you the right to do that. In count 4, plaintiff has asserted a claim for damages against a governmental entity arising out of violations under the New Mexico Constitution. As such, it is barred by sovereign immunity unless the New Mexico TCA, the New Mexico Tort Claims Act, contains a waiver of immunity, holding that holding the New York Unified Court System is unquestionably an arm of the state, and plaintiff's claims for damages against the New York Unified Court System were therefore barred by the 11th Amendment. And so courts have found that state court systems are part of the state government, which is not unexpected. I mean, considering that every state has to have a Republican form of government with the 3 branches, so every state has a governor. Even the Commonwealth will have a governor. They'll have a legislature of some form. Some are bicameral, some have only one house, I guess, and then they have to have a judiciary. So every state has that basic setup, and so it should not shock you that the judicial branch of a state government is part of the state government. Plaintiff argues that the New Mexico Tort Claims Act waiver of immunity for violations of civil rights applies here. The waiver provides, in relevant part, a public body or person acting on behalf of Stop it. Really? God damn it. You guys are going to get to enjoy a little bit of yeah, bakbakakik you. Sorry about that. So the waiver provides in relevant part a public body or person acting on behalf of, under color of, or within the course and scope of the authority of a public body shall not be subject or cause to be subjected any resident of New Mexico or person within the state to deprivation of any rights, privileges, or immunities secured pursuant to the Bill of Rights of the Constitution of New Mexico. B. A person who claims to have suffered a deprivation of any rights, privileges, or immunities pursuant to the Bill of Rights in the Constitution. I don't know what the hell's going on today. People are coming and going. Jesus Christ. Everything's going on today. Or under color of within the course scope of authority of a public body may maintain an action to establish liability and recover actual damages in equitable or injunctive relief. And then the court has underscored in any New Mexico District Court. That's the court's underscore. You can see here it says emphasis added. By its own terms, this waiver is limited to actions commenced in any New Mexico District Court. It's almost like I said the exact same fucking thing. Crazy. The 10th Circuit has interpreted analogous language in the New Mexico Tort Claims Act to mean plaintiff cannot pursue a claim against a state public body and its employees acting within the scope of their employment in the federal district court, but rather is relegated to the state district court to seek relief consistent with the limited waiver of immunity under the New Mexico Tort Claims Act. The Valdez further rejected the plaintiff's argument, which plaintiff also makes here, that the court had supplemental jurisdiction over the complaint's claims under the Mexico Civil Rights Act because immunity under the 11th Amendment is not abrogated by 28 U.S.C. 1367, and therefore 1367 does not authorize federal district courts to exercise jurisdiction over claims against non-consenting states. The court agrees with this analysis and adopts it. Consequently, the court finds that Count 4 is barred by the 11th Amendment immunity. Well, here's the thing, Laura. Why don't the attorneys listen to Merb more? Because I'm just a first-year family law attorney, and all attorneys think that they know better. You show me an attorney, and I will show you an attorney who thinks he knows more about the law than I do. And that's fine. There are lots of attorneys out there who know lots more about lots of different laws than I do. The point that I normally am making is that if I can figure it out, as a first-year family law attorney, if it is obvious on its face to me, if I can find the sections of the law that preclude some form of cause of action, then why can't, for example, the best attorney in the state of New Mexico, why can't that attorney find the same language, do the same kind of research, find the same kinds of cases that say that it has to be a New Mexico State District Court? But I'm not entirely sure. I'm not entirely convinced that Springer is paying for this. I think it is more probable than not that Springer is not paying anything out of pocket on this. I think it is more probable than not that A. Blair Dunn, who seems to like to file lawsuits against the government at the drop of the hat, whether they have merit or not. I mean, this is the dumb motherfucker who sued the New Mexico Supreme Court. He sued the New Mexico Supreme Court and got sanctioned over it because it was a frivolous lawsuit that that a law school student should know. You like judicial fucking immunity applies. You can't sue the goddamn New Mexico Supreme Court, at least not over the kinds of things that he was suing them over. They have judicial immunity. Well, so I didn't say that A. Blair Dunn is doing this for nothing. You'll notice in his second amended cause of action that one of the things that he was seeking was attorney's fees payable by the 7th Judicial District Court. And I'm sure those attorney fees would be substantial, because the best attorney in the state of New Mexico would obviously clearly charge a lot of money despite the quality of his work, and he would be seeking an order from the federal district court granting him those attorney's fees under 1980. What is it, 1985 or 1988? I forget which. It's 1988, I think, that grants attorney's fees to prevailing parties. So, conclusion. It is hereby ordered counts 1, 2, and 3 are dismissed with prejudice to the extent that they seek injunctive relief and declaratory judgment regarding past liability. That's even more crazy that he thought he could win this. You know, the more attorneys that I deal with in my YouTube career, the less shocked I am by how stupid, naive, ignorant some of these attorneys can be. Because it's different when you're like when I'm in a case with opposing counsel, family law, civil, whatever. There's normally I can understand why the other attorney filed. So, for example, one of the very first things that I learned in my law practice, in my legal practice, working for another attorney, was that all cases have settlement value. There is some settlement value to any case, no matter how bad it is. So if you know how to settle it and when to settle it, you'll get something for it. It might be $1. It might be $100. It might be $1,000. It might be $1 million. But all cases have settlement value, right? So when I am involved in a lawsuit with someone, with an opposing counsel, I can kind of see where he's coming from. But in this particular case, when you're suing the federal government, or when you're suing the state government, and state judges, and they have a clear out, an easy out, maybe he could have settled this. Maybe there was some way to settle it, but the state government doesn't have the same kind of pressures as a individual litigant would have. So your odds of getting a good settlement drop dramatically if the other side has fuck you money. And a state has fuck you money, where the state, might want to just go ahead. It might not even occur to the state that they want to settle it. And I don't think that Freeman's attorneys even tried. But like, if, for example, unbeknownst to us, Blair Dunn and his team were in communication with that Jade Delphine gal who is the attorney for the defendants, if Blair Dunn and his team were in contact with Delphine and her team, and they were actually trying to settle the matter, then it starts to kind of make sense a little bit to me, because then I can be like, okay, he knew he had a shit case, but he was trying to get something out of it, right? And maybe he miscalculated, and he was asking for $10,000 when the state would only be willing to give him like $100 or something like that to make the case go away. And I'd be able to kind of understand it. But not being able to see those kind of internal discussions leads me blind as to whether or not Blair Dunn was even smart enough to try to settle the case, to try to get a few dollary dues out of it. But I don't think that Blair Dunn was doing that, because who would he have been negotiating with other than Delphine? And he was letting his client insult Delphine the entire time. Paul Berry says, I think Eline mainly negotiates settlements out of court and or offers a referral service. He probably does offer a referral service. Most attorneys do. Like, for example, if you came to me looking for immigration services or tax services, I have attorneys that I'd be like, oh, you should go to this guy, and I'd let the other attorney know, and they might throw me a couple bones for sending a client their way. So that's, I mean, pretty much. I don't know of any attorneys who don't do referrals, but yes, a personal injury attorney 100% negotiate settlements out of court. That's 99.99% of personal injury. Something goes horribly fucking wrong. If it's a something has gone horribly fucking wrong. If you are representing a client on a personal injury case and it actually gets into a trial. If it goes to trial on personal injury, shit's gone downhill. Ken Before the Storm says, I filed 2 federal cases from my false arrest pro se. Shit gets deep fast. Working on a response to their motion to dismiss while I listen to this. Well, I mean, good luck, sir. Good luck. If here's again, I've given this advice before, Ken Before the Storm. If you can't find an attorney to take your 1983 lawsuit on a contingency basis, i.e. he doesn't get paid anything unless you recover. If you can't find an attorney to do that, you have a shit case, which means you're probably not going to recover. And the vast majority, the overwhelming majority, almost all pro se 1983 cases get dismissed. Almost all. You're looking at a fraction of a minutia of them that actually where the pro se plaintiff will get to trial, let alone succeed at trial. And while you're working on your response to their motion to dismiss, you might want to consider trying to negotiate with them. That's something that pro se litigants don't seem to understand. Is that attorneys in general on cases like that, hashtag not all, hashtag I haven't done an actual study, but in my experience, attorneys who are engaging in that kind of litigation are going down 2 tracks at once. Number 1, they're trying to get their case to trial. And number 2, they're trying to work on a settlement agreement. So if you have not been engaging opposing counsel with settlement negotiations, then, well, that sucks for you. Dumb Josh is into house. Okay. The bad Josh, the wrong Josh. The not funny and not smart Josh. The annoying Josh. He has lots of adjectives that we could throw on. Haha, good luck equates to fuck. No, I mean, so he might actually. I'm assuming that the gentleman who's working on his response to the motion to dismiss actually believes, and I don't know anything about his case, but I'm sure he actually believes that it was a false arrest. Fourth Amendment violation, great. The issue that he's going to run into is that his beliefs really aren't important. But I'm not saying to fuck off. I'm saying good luck. You know, I mean, he might have actually been falsely arrested. And if he is falsely arrested, then he should be compensated for that. But good luck. The one thing that people seem to forget is it doesn't take, you don't have to actually be guilty of something to be arrested for it. You don't, so he's saying here, I hear you, but I got all 7 charges dismissed pro se, and the judge said there was no reasonable suspicion or probable cause. Well, first of all, I don't know if that is the case or not. The fact that you haven't gotten past the point, I mean, if there was an actual finding by a lower court judge or by a state judge that there was no probable cause, I don't know. I see if the state court found there was probable cause, then that would be a different issue. Regardless, probable cause is an incredibly low standard. It's a infinitesimally low burden of proof. The old saying is that you can indict a ham sandwich. Ham sandwich is based on probable. The ham sandwich. Well, you can indict a ham sandwich, and that is to show that probable cause is something that is very easy to show. All the officer has to show, or all the to defend himself in your 1983 lawsuit, is to show that under the information that the officer had at the time, just the information the officer had at the time, that the officer could have concluded that a crime had probably been committed and that you probably committed it. Merb, a lot of attorneys engage in any communication with pro se litigants. I don't think so. I have never seen it, and I've seen lots of communications between attorneys and DeCastro, and DeCastro is a very he is not very polite in his communications, and so even with that, they still communicated with DeCastro. I've never seen an instance where an attorney would not communicate with opposing counsel, or if the opposing party is pro se, then with opposing party. He must have offered that opinion. Never Too Soon says, I liked your guest opinion yesterday about an elected jailer working for a 14-time felon. He must have offered that while I was not here. Ken Before the Storm continues, also did a FOIA and got emails showing they only arrested me for First Amendment retaliation when they put the YouTube videos up. Well, I mean, you could think that. Too often I see people misinterpret things. For example, I had a trial scheduled for, it was last week. It was like the middle of last week. Anyway, the morning of the trial, my expert sent me an email saying that he was sick. He was super duper sick, and he wasn't going to be able to testify well. But if I absolutely needed him to, he would do it. And this was against opposing party was pro se. So I sent a email to opposing party. Hey, my expert is sick, and just so you know, here's the California rule of court showing that it's good cause to continue a trial if someone's expert is sick, and so the court will continue it anyway. Can we just agree and maybe pick a new date, and we could send in a stipulation to the court? And opposing party said no. He didn't think so. So I show up to the trial. It was just a half day trial. It was set for the afternoon. It was basically just for the expert opinion, and so I get the expert report in. It's a DCSS case. Anyway, I had the expert, and I told the expert, he said no, so I'm going to ask to get it continued, but I want you to be available to appear by Zoom if necessary. Well, anyway, I get there, and the expert's already on Zoom. I'm like, okay, this is bad. And opposing parties there, and this guy, just so you know, the expert was a goddamn chickens. The expert was a vocational evaluator. Our position was that opposing party was suppressing his income, and so he had been evaluated by the vocational evaluator, and the vocational evaluator determined that this guy had he was in the bottom 1% of IQ. He had a fourth grade reading comprehension. I mean, this guy was dumb. So we show up there. I'm like, all right, okay, so my expert's on Zoom. That means something went wrong. And opposing party was like, man, I got you. I'm like, oh, okay. Like, what do you mean? He's like, I went over to the expert's office and he was there. Okay. Like, okay. I don't know what your point is, but he absolutely thought he got me. And so when the judge was ready and the case was called, I'm like, Your Honor, we're asking for a continuance because my expert's sick. And so the court just like, okay, when's your next available date? Opposing party's like, he starts throwing a fit. Like, wait a minute. I went to the guy's office and he was working, and here he is on Zoom at his office. Obviously, he's lying, right? He's obviously not sick, and the court's like, no, he's sick. I know the guy, I know the expert, and he's sick. He says he's sick. He's sick. Like, we're moving on. When's your next available, counsel? So a lot of times, and don't take this the wrong way, Ken, before the storm, but a lot of times people, pro se litigants, misunderstand relevance, and they read things like emails in a way that an unbiased person wouldn't. And I just want to caution you again that you may be aware that no attorney took your case. And again, if you can't find an attorney to take your case on contingency for a 1983 lawsuit, you've got problems. You've got real problems. There's problems with your oh boy, you scroll down a lot. And after the deposition, SmackDown, did the armed fisherman win the case? I've never seen a pro se litigant do well at deposition. If there was no probable cause, then the charges would have never been filed. Someone found probable cause in the affidavit submitted. Probably. It's too early in the day for logic. It happened in my divorce case in Florida while you're peeing. Yeah, okay. Squatted? Sir, I do handstands when I pee. How are you going to get your new fish tank set up if you are on here doing lives 24/7? I'm not doing lives 24/7, and I have to get plumbing materials. I've got to get 3-inch pipe because I'm moving filtration for the big tank into another room. I've got all sorts of things to do. Careful to question that man who'll get awful sensitive and upset and start screaming and yelling and calling you stupid. He's always right. Remember that. I'm always right. Okay. My puppy is doing so much better. Thinking we her off the rice part of her diet. Okay. Merb, you're the gem. Am I? Put the cocktail away, Merb. I didn't know I had a cocktail. Shocker that the wanted felon directee can't spell right. They're not. That's not Morning Delight. We're jumping. That's not Morning Delight. That's a chicken doing her egg song, but they're not. We're down to one guinea fowl, Paul, and we've named him Patrick, and he's not. He or she or it is still around, but that's a chicken making that noise. Tell Elon to quit all the cackling in the background. Okay. Been a long weekend. Merv is playing GG. I don't understand what that means. Everyone knows you're a rat. It's not a big deal, pal. I'm a rat? Okay. Last time I checked, I am not a snitch, but okay. Ken before the storm says I should take advice from DirectD, scam a bunch of people to get warrants and then run away like a coward. Okay. Merv's gonna be laying pipe. Yeah. Well. Yeah. Sure. We're all good, buddy. Okay. Merv admitted he has a 3-inch pipe. 3-inch in diameter, Paul. 3-inch in diameter. All right. It's like a bundt cake. It's only that tall, but it's that big around. Thank you, though. DD, say what you mean and mean what you say. DD method of truth finders is the same. Direct D, love ya. We're all rats to you. Tough guy, big to differ. We don't all learn the hard way. Okay. So anyway, as the point of this stream was just to say that Counts 1, 2, and 3 are dismissed with prejudice, and to the extent they seek injunctive relief and declaratory judgment regarding past liability, they're dismissed without prejudice solely regarding the constitutionality of Judge Murphy's administrative order and amended administrative order, and dismissed without prejudice for lack of subject matter jurisdiction for count 4. Defendant's motion to dismiss plaintiff's second amended complaint for declaratory and injunctive relief is denied as moot, so the court is just dismissing it based on the judge's order to show cause. Defendants Poff, Jones, Rossingall, and the 7th Judicial District Court are terminated from the action, and plaintiff has 14 days within which to file a third amended complaint for prospective declaratory relief against Chief Judge Murphy in her official capacity. However, plaintiff is advised this may be the last amendment the court permits him to make, so care should be taken to remedy all deficiencies, whether discussed in this order or not, i.e., your complaints so far have been pure shit, and maybe you want to make sure, maybe proofread them, maybe make sure that they allege all necessary elements of every cause of action, maybe? I don't know. Maybe you want to do that? Anyway, being the height of stupidity, Blair Dunn has filed a notice of appeal. So he's going to appeal that order. Now, I don't know why he would appeal that order, and the reason why I don't know why he would appeal that order is because if he had a fucking legitimate argument, he would have set it forth, or he should have set it forth in the opposition to the order to show cause. Should have. Woulda, coulda, shoulda. Didn't. When are the courts going to stop being so prejudiced? Just saying, lol. Okay. Pure shit is not good legal analysis. Do better. Sorry. It is, yeah, no, it's pure shit. All right, anyway, that's it. Thank you for watching, and I'm going to try to figure out how to terminate this stream. Other than that, you have a great day.